Hey folks, I want to play for you my presentation, my speech that I gave just recently at the 2025 National Lawyers Convention of the Federalist Society down there in Washington, D.C. It was an incredible event with thousands and thousands of lawyers and scholars and judges and journalists and influencers. It was an amazing event. It is an amazing event every year, which is why I like to speak there. I'm always honored that they invite me every year. I think I've been invited for the last, 8 years plus. I've lost track at this point. And I always try to do a good job and talk about the Second Amendment because it's such a critical topic, especially in today's world. If you ever get a chance to go to the Federalist Society events, you definitely want to go because, the Supreme Court justices are there. I mean, for example, I was lucky enough to be close to the front row during the Antonin Scalia Gala dinner. And, here's a photo that I took of Justice Amy Coney Barrett, where she spoke about, among other things, her new book. Given the fact that Christmas is coming up, I'm sure this is a good time for her to do her book promotion. And also another great justice spoke, who, of course, with Supreme Court Justice Brett Kavanaugh, he also talked about the notion of courage and wisdom and the process of judging and some of the things he's observed in the passing scene going all the way back to the George W. Bush days. And he did a great job presenting at the Federalist Society well. So, and of course, one of the friends of our channel who's appeared on this channel, the U.S. Court of Appeals Judge Amal Thapar, of the Sixth Circuit down there in Kentucky. He also gave a great presentation, and it is a great honor from my point of view to be able to speak, at an event alongside, if you will, Supreme Court justices like Justice Barrett, Justice Kavanaugh, and of course judges like Judge Amal Thapar of the Sixth Circuit. Thousands of people go to this. It's a great dinner on Thursday night. And then, of course, the presentations go on for a couple more days. A lot of interesting things. Members of the Department of Justice spoke about some of their issues and the like. So it was great. And again, here's the presentation I gave. I was introduced by the moderator of the Second Amendment panel, Judge Paul Mady, who's a judge on the United States Court of Appeals for the Third Circuit there. And there you have it. So make sure you check out this speech. Let me know if you agree or disagree with anything I had to say. I know it's going to be geeky, but I had to be geeky because I think these are really important issues. And given the nature of my sophisticated audience, I thought being super sophisticated and super geeky was appropriate and helpful. At least that was my goal. Let me know if I succeeded. I was taught that if I'm in a room with an honorable judge, I should always stand. So I'm going to stand. Let me begin with some observations, big picture-wise, about the state of the battle involving the Second Amendment in America today, specifically in a post-Heller world. Since Heller, this fight has played out in two acts. Act one was post-Heller, and in that act we saw massive resistance by the lower courts who simply thumbed their nose at the Supreme Court, pretending they could not figure out Heller, pretending they could not figure out the text of the Second Amendment that says the right of the people to keep and bear arms shall not be infringed. How much clearer could you write that? While feigning this ignorance, guess what? The consequences were predictable, which is with virtually every case between 2008 and 2022, with rare exceptions, the government won and the Second Amendment was relegated yet again to a second-class right. And that gave rise to Act 2, which is the Supreme Court decision in Bruen, which really was a sippy cup, paint-by-numbers way to the lower courts, the Article 3 inferior courts, no offense, Judge, that says specifically, this is how you apply Heller, and we're going to paint it out for you in a paint-by-number way, and that's what Bruen was. Heller and Bruen are the same approach, the same methodology. It's just Bruen is really written out in a paint-by-numbers way so the lower courts could not screw it up a second time, which gives rise to what? Basically, the lower courts no longer could get away with saying, we don't understand anything about Heller. We now need to come up with a new way to engage in a rearguard action to undercut and eviscerate the right to keep and bear arms, in particular in those blue state jurisdictions where the blue slip continues to play a role into the outcome of some of those decisions. Specifically, what we've seen is an attempt in some of these lower courts to find other ways to refuse to respect the right to keep and bear arms, and I want to identify two of them right here and right now. The first game that's being played is what I call the facial challenge game. And this is basically based on the 1987 Supreme Court decision of the United States versus Salerno. In 1987, the court decided Salerno that says when you're dealing with a facial challenge that the party must succeed in demonstrating that the gun control statute, and there it wasn't a gun control statute, but that the statute itself is unconstitutional in all applications. This is what is basically known as the Salerno principle. Now, it sounds simple enough, but this is the game that we're seeing played in many of the lower courts today, and that is the judges are misapplying the Salerno principle to shut down facial challenges to modern-day gun control laws. And how exactly are they doing this? Well, since Rahimi, the lower courts have found this way of doing it, which is really kind of a version of fantasy judging, I kid you not. What I mean by that is these lower court judges are imagining in some sort of a fantasy world a narrower version, a hypothetical version of gun control statutes that are not actually the cases or not actually the statutes being litigated. Let me give you a hypothetical to illustrate the point. Let us say that someone today challenges a DC ban on handgun possession. And let's pretend for the moment that Heller does not exist. The district court playing the Salerno game would do the following. It would say this. Well, we know that it's perfectly constitutional under the Second Amendment to ban felons from having handguns. So therefore, there's at least one constitutional application to a handgun ban in D.C. Therefore, the facial challenge to the D.C. handgun ban is constitutional, or it falls by the wayside and cannot be sustained on a facial basis. Of course, the problem is with that hypothetical statute dealing with the D.C. handgun ban, there is no element in it that says you have to be a felon. The statute as it was written is unconstitutional in all of its applications because that felon element that hypothetical court would use as the hook to uphold the statute is not actually in the statute. In essence, they were rewriting, or they would be rewriting a statute that's being challenged in the abstract compared to the actual gun control laws being challenged in the real world. So before we go any further to illustrate the problem and how this is getting played, I want to put out some general principles. To begin with, a facial challenge to a gun control statute is a claim that the statute is unconstitutional in all its application, not just to the specific case in front of it. Now, this, of course, contrasts to what are known as applied challenges, which argues that the statute is unconstitutional when applied to the particular facts of a particular plaintiff. Now, understand this distinction between facial challenges and as applied is extremely important for Second Amendment litigations, because here's a real-world example of how it plays out. Just a couple months ago, the United States Court of Appeals for the Fourth Circuit in a case called Lefebvre versus Fairfax County upheld a ban on handguns and all firearms, frankly, in parks in Fairfax County. Now, there are 420 parks in Fairfax County, consisting of 24,000 acres. That's over 9% of Fairfax County as a park. To put that in perspective, by the way, that is almost twice the size of the borough of Manhattan, which the Supreme Court in Bruen said specifically you could not declare the borough of Manhattan a sensitive place, a gun-free zone, constitutionally under the Second Amendment. And yet that's what the Fourth Circuit did. And how exactly did they do that? There are four parks in Fairfax County had preschools in them out of the 420. So what did the Fourth Circuit do in light of that? And how did they use the fact that 4 of the 420 parks had preschools in it to uphold the law and deny the facial challenge? They said simply this. They said, well, look, the Supreme Court has said in dicta that firearms can be banned in schools. That's what they indicated in Heller. And because 4 of the Fairfax County parks have schools in them, a facial challenge to that law that says no guns in the parks is upheld because there's at least some constitutional application to at least the parks with the schools, and therefore facially you cannot knock the law out. And that's what Chief Judge Albert Diaz wrote when he says, quote, that's enough for us to reject the facial challenge. Of course, what the Fourth Circuit did here wrongly is they imagined a statute that said no guns in parks that happen to have schools. But this is wrong because the hypothetical statute that actually has an essential characteristic of a school in a park in Fairfax County was not the actual statute that was being challenged, because the statute simply said no guns in parks in Fairfax County. So they invented a law, sort of a straw man law they invented, and then they analyzed the law under the Bruen methodology and then upheld the actual law, even though the actual law was written differently than the hypothetical law that they used to knock out the facial challenge to the actual law. Indeed, if you think about it from the perspective of a prosecutor to convict a defendant of carrying a gun in a park in Fairfax County need to only show that you had a gun in Fairfax County in a park and you're convicted. The presence of the school is not relevant. The prosecutor doesn't have to show the presence of a school to win the case. And yet it was the presence of the schools in the parks in Fairfax County that was the hook that allowed the court to deny the facial challenge. And this is not correct because the actual laws have to be analyzed and not some hypothetical law. Now, is there a solution to this problem which we keep seeing over and over and over again in the lower courts? And the answer is yes. And that is, take a look at what the Supreme Court did in Heller. Heller, in 2008, of course, literally said that the District of Columbia's handgun ban was facially unconstitutional. But guess what the Heller case also said simultaneously with that holding? It literally says, well, it's true that the Second Amendment might permit bans on felons possessing firearms. It might permit the ban on fully automatic machine guns. It might allow for bans in government-mandated gun-free zones or sensitive places. Now think about that for 1 second. Despite the Supreme Court in Heller saying that the Second Amendment would permit the banning of these items consistent with the Second Amendment, it still knocked out the gun ban, the handgun possession ban in D.C., notwithstanding that. Keep in mind about Heller and facial challenges. The Supreme Court in 2015 in Patel versus City of Los Angeles literally called the Heller case a facial challenge and really an exemplar of it. And that is because it was. So whenever someone is faced with a facial challenge in a Second Amendment litigation and you have the Salerno principle thrown at you, keep in mind what Heller actually did. Now, what you often see now is that some advocates for the gun control side of things say that, well, Rahimi knocked out a facial challenge, so that shows what we should be doing, and Rahimi is always cited for this. But look at the statute that was challenged in Rahimi. Rahimi was an extremely detailed statute that says that it's 18 U.S.C. 922 G8, a prohibited person statute, that said that if you can be banned from having a gun if there's a restraining order found by a court and a credible finding or a finding that you are a credible threat to the physical safety of another person. It's an extremely detailed statute. And the Supreme Court analyzed all of these and concluded that under the Second Amendment's history and tradition, it is the case that you can be temporarily banned from possessing firearms if you are found by a court to be a violent danger to someone else. And therefore, they uphold the Rahimi law by actually looking at the actual lawsuit. Of course, this is much different than what the Fourth Circuit did, which again, they added elements to the statute that was being challenged to save it. And that is simply not appropriate. Now, there's two reasons policy-wise why this is totally wrong. One is a separation of powers problem. You should not have courts rewriting statutes and then discussing them. They should analyze the statute as written. And as a practical matter for those people that represent Second Amendment rights claimants, by eliminating facial challenges to gun control laws, you make it much more expensive, much more difficult and time-consuming to ultimately win those cases. And it makes no sense to say that these facial challenges cannot work, because let's think of a more basic hypothetical example. Let us say that there is a law that bans guns in a county or in a state or in the country. Well, we know the Supreme Court has already said that there are so-called sensitive places where you can ban guns. So that means in every county, there's at least a prison and a courthouse. So you would mean you cannot facially challenge that no guns are allowed or no guns can be possessed in the county. The same for the state, the same for the country. That is simply an absurd result and cannot be the case. And I will just say an excellent example of a court getting it right was the Illinois Supreme Court in People versus Burns in 2015 that said that the Illinois had banned public carry without mentioning the felon element. And when the state of Illinois prosecuted Mr. Burns, who actually was a felon, the state Supreme Court said, you can't do that because the law doesn't talk about felons. And here's what the court said. An unconstitutional statute cannot become constitutional simply because it is applied to a particular category of persons who could have been regulated had the legislature seen fit to do so. And that, of course, is the point. So to conclude on this point, judges need to assess the laws as written. They should not invent elements that don't exist and then opine on the legality of those hypotheticals. Now, the second main area where we're seeing games being played is this critical distinction that no one talks about because no one thinks about, and that is the distinction between legislative facts and adjudicative facts. By mislabeling, this is a big deal, folks, in the real world, because by mislabeling legislative facts as adjudicative facts, lower courts are forcing Second Amendment rights claimants to engage in unnecessary and time-consuming litigation processes. And this legislative fact versus adjudicative fact issue is extremely important because a lot of these bad gun control laws are in bad jurisdictions where the judges, frankly, as Eric kind of alluded to, are kind of down on the Second Amendment. And again, I think the blue slip process in the Senate contributes to this. Now, here's the thing about this. Judge Posner in the Seventh Circuit in Moore versus Madigan drew this distinction between the two. And again, this is often ignored in litigations, but it shouldn't be. In his opinion in Moore versus Madigan, which is a Second Amendment challenge to an Illinois ban on guns in public, he offered this critical difference or distinction between legislative facts and adjudicative facts. Judge Posner wrote, legislative facts bear on the justification for the legislation. Adjudicative facts concern the conduct of the parties in the particular cases. Judge Posner went on to say that only adjudicative facts are determined in trials and only legislative facts are relevant to the constitutionality of, in that case, the Illinois gun control law. Now, this is quite important because the Supreme Court draws this critical distinction between legislative facts, which is about the law, the Constitution, versus adjudicative facts, which is about the parties. If you look at the Heller decision, if you look at the McDonald decision, if you look at the Bruen decision, if you look at the Caetano decision, if you look at the Rahimi decision, what do they all have in common? None of them involve expert testimony, none of them involve witnesses, none of them involve discovery, none of them involved all the sorts of things that you see in a normal litigation involving adjudicatory facts, which is, did Mark drive the car through the red light? Did Mark run into the tree? Did Mark get kicked out of the bar? Whatever it is. Because when you're talking about the Second Amendment issues and whether or not something is constitutional or not, those are legislative facts that do not require the same sort of process and trials and time-consuming money spent that you see in a normal case dealing with adjudicatory facts. Now, by the way, if there's any doubt that the Supreme Court views legislative facts differently than adjudicatory facts, you only need to look at Heller and Bruen specifically, because in both cases, parties asked the Supreme Court to remand the case back down to the lower courts for more fact-finding, for more evidence. And in both cases, in Heller and Bruen, the Supreme Court said no can do. In Heller specifically, the Solicitor General Paul Clement literally asked the Supreme Court to remand the case back down to determine whether or not the handgun ban was constitutional, and the Supreme Court says we don't need to do that. We're going to decide it right now. The handgun ban is unconstitutional because handguns are protected arms, period. Likewise, in Bruen, if you take a look at the dissent, it talks all about, from Justice Breyer at least, the importance of having more fact-finding, remand in this case for more fact-finding, because that's what New York needed to assess the licensing regime. And again, in Bruen, the Supreme Court says, no can do, we don't need to do that. These are legislative facts, we don't need more evidence, we don't need a trial, and the like. And just to summarize why legislative facts versus adjudicatory facts is mission critical in the real world of Second Amendment litigation, is because they're governed by different rules. With legislative facts, courts have unlimited investigative authority. The rules of evidence do not apply. There's no authentication. There's no hearsay concerns. There's no Daubert issues. You don't have to spend time and money wasted on experts and expert depositions. Appellate courts, like Judge Mady here, gets to review all the decisions de novo, so the trial court findings are not entitled. They're not entitled to clearly erroneous deference on appeal. And again, the reason makes a lot of sense, because if you think about it, if you're trying to determine the meaning of the Second Amendment, you don't want the meaning of the Second Amendment to get screwed up because some lawyer dropped the ball on some sort of particular issue. So you always want to give the courts the ability to use legislative facts to understand the meaning of the Second Amendment. And if you want to have a great example of this, one need look no further than Justice Sam Alito in his concurrence in the Caetano case in 2016, where he talks about stun guns. And in that discussion of stun guns, did he ask for expert testimony and more fact-finding in the lower courts? No, he did not. Justice Alito literally cited to a Michigan case, citing to a law review article, citing to a 1985 newspaper article, because that's how legislative facts work. So again, those are the two things you need to pay attention to: the facial challenge game that's getting played to knock out Second Amendment challenges, and the distinction between legislative and adjudicative facts, because if frankly, the government defendants are always asking for adjudicative facts because it drags the case out for years when it doesn't need to be. And don't take my word for it. Just look at how the Supreme Court has decided Second Amendment cases time and again. They use legislative facts. They don't need trials, experts, and discovery and the like. Thank you.
Orders up. Table 2A.